Good morning, Ms. Cox.
Good morning. May it please the Court, Jennifer Cox here today for the defendant Peterson Charles on his appeal from convictions from the Brockton District Court. Mr. Charles was charged with 3 drug offenses, 2 for possession with intent to distribute, 1 a Class B substance and 1 a Class D substance, and a corresponding school zone violation. To prove the elements of the identity of the substances at trial, the Commonwealth presented 3 certificates of drug analysis. Although the defendant did not object to the evidence at trial, he maintains on appeal that due to the timing of his trial, he is entitled to the clairvoyance exception to the waiver doctrine, and that the harmless error standard of review should apply.
It would be helpful to me and for counsel who are going to follow you if in each case when there was a failure to object, whether you could tell me where it fell in connection with the following cases, in relation before or after Verdi, in relation before or after cert had been granted in the United States Supreme Court, and before or after the decision of the United States Supreme Court in Melendez-Diaz.
Yeah.
Okay.
This case, his trial was in September 2007, so it's post-Verde, pre-Melendez-Diaz decision, and pre-grant of cert.
I think that's true, actually, of all 3 of the cases that
I
were here.
believe it is, yes. So the defendant argues that the clairvoyance exception applies due to the timing, and in support of that, I would argue that although in his decision, Justice Scalia says that the decision in Melendez-Diaz is no more than an application of the Crawford holding, in fact, that's sort of an overstatement of what happened. A simplification of what happened. I would argue that Melendez-Diaz is a new rule. If you look to the language of Crawford itself at one point, Justice Scalia discusses, he refers to the business records exception to the hearsay doctrine as something, I believe the words are, by its very nature is non-testimonial.
Business and public records.
Yes, correct. So I would argue here that the Melendez-Diaz decision, obviously this court came out the other way on it, as did many other courts throughout the country.
So let me ask you this, Ms. Cox. It's a practical matter. Don't put it into any of the boxes, right? As a practical matter, the Supreme Judicial Court has just decided Verdi. You're the defense attorney. Why don't you raise the objection to the introduction of the drug certificates?
I think at the heart of it is because any lower courts, their hands were tied, although the defendant recognizes that.
So would it be fair to say because you think it's a waste of time?
Yes.
Right.
Wouldn't the judge have gotten annoyed at you and just said, look, the highest court of our state has just said,
Yep,
what
and
are
I've
you
read
doing up here
those.
wasting my time?
I've read plenty of trial transcripts that say, where there are an objection, that say just, basically, I can't do anything.
But your objection is preserved.
Right. That's
And
right. You're
many
preserved.
lawyers did just
And if you
that.
fall within the 4 years or 5 years between Verde and when Melendez-Diaz was decided, and you're lucky enough that your case is still pending at the time the Supreme Court decides, then you have relief. But yes, there was nothing. And if you read the several.
So if I'm a defense attorney and I do object, and I'm in front of trial judge Cowan, knowing that she's going to say, don't waste my time, move along. And by the way, I've got another case the next day before Judge Cowan. And what am I going to do the second day?
Well,
And by the way, it's a bench trial this time around.
as a practical matter, while several counsels did object, several didn't, and I believe that was why. While I certainly can argue that the better practice, knowing that it was a federal constitutional issue, would have been to object.
Yeah, but there are
It
lots
really
of
would have been
cases. There are
futile
lots
at
and
that
lots
time.
of cases.
I'm sorry. Could you
There are lots and lots of cases where they're federal constitutional issues, and as I recall under Verdi, didn't we decide it under the federal constitution, Justice Island?
correct.
Yeah.
I think that's right.
I think that's right, right?
Mhm.
And we do that all the time.
Right. And I
But
would argue that
I suppose what I'm really looking to, the clairvoyance exception, it's not clear to me where that plays in with the futility, the don't waste my time.
Okay, well, I think that goes back to my previous point that Melendez-Diaz was not clear from Crawford. It was not a foregone conclusion. Even when the court accepted cert on the case, Melendez-Diaz turned out to be a split decision. I mean, plenty of justices, even of the Supreme Court, disagreed with the outcome of whether it wasn't the application of the Confrontation Clause so much as it was the precise issue of whether these sorts of forensic certificates are testimonial or non-testimonial.
But wasn't the issue smoldering all across the country?
it was the next step after Crawford. It was the next wave. I mean, Crawford was a sea change, and in the first wave was the the hearsay, the spontaneous declarations. The next wave was something else, and we're not done.
Right. Yes, you're not. And I would agree with that as a practical matter, but I think that the tide sort of turned once courts like this one decided Verde and other decisions across the country. It quelled that to an extent.
Would you agree that at this trial, in this case, the nature of the substances was not a live issue, whatever that means?
I would disagree with that, and I can succinctly say it that my position is that anytime there is not an express stipulation to the substance, for these purposes, it's a live issue.
So if counsel gets up in the opening statement, defense counsel, and says, okay, we've got marijuana and cocaine, but it's not my client's marijuana and cocaine because he was not in the car, it was someone else's car, so that, yes, the Commonwealth has to prove that it's marijuana and cocaine, but would you say in that circumstance it's not a live issue?
I think you'd have to decide at that point whether that, I mean, opening arguments of counsel are not evidence, but the issue at that
no
point
cross-examination on the question, no
concession?
cross-examination when the officer gets up and says, I'm an experienced officer, I recognize this immediately as marijuana, no cross-examination on, well, you're really sure, can you tell the difference? So no attempt at all to challenge that evidence.
Right.
Still a live issue?
I think it's more problematic in the case that you raised where it's in the opening argument where counsel says that. This case is a little different where I have to concede that in the closing, defense counsel says, I ask you, based on the evidence, I ask you find my client guilty of the lesser included offense of possession. I think once you say that, you're sort of conceding.
But can we say that the Commonwealth can satisfy its burden of proof by the defendant's silence? I mean, doesn't the Commonwealth have to prove every element beyond a reasonable doubt, and they can't do it by the silence of the defendant? I mean, isn't that your position?
Correct. Yeah, that is precisely the position.
Excuse me.
Well, I mean, if you accept your premise that harmless beyond a reasonable doubt standard applies, I take it your position is that when you've got a substantive element that the Commonwealth has to prove, as in this case, that how can you say that the certificate of analysis didn't or might not have affected the verdict?
Right, correct. That is the position. And to go back to what Justice Cowan was saying, it is, obviously we all agree it's the Commonwealth's burden of proof on each element of the offense, no matter what the theory of the defense is.
It's akin to a public way.
Yes.
Correct?
Yep. Correct. Yeah,
You
there's
have to
plenty
prove
of
it's a
times you
public
could
way.
stipulate to that.
You get up there, you
Yeah.
don't say, now are you quite sure, officer, this was a public way? I mean, is it on, whichever way you prove a public way?
Right.
Was there any other evidence in this case that the substance was cocaine?
The only other evidence besides the certificates was the testimony of two officers. There were three officers that testified, but one essentially was the expert who testified about the packaging. He didn't make any he was not asked to identify the substances, so it's just the two officers. And it basically is their conclusory references throughout the trial, saying, what did you find when you looked at the bag that was thrown in the back? What was in it? It appeared to be marijuana. It appeared to be crack cocaine. It was a green leafy substance. It was an off-white hard rock substance.
Was there an objection to that testimony?
No, there was not. There was no objection to that testimony coming in. But it was so I would note that while on some occasions the officers both did say, I found marijuana, I found crack cocaine.
Were
they
these
also
police
qualified.
officers, were they experienced in detecting drugs?
Well,
Was that offered in evidence?
But one offered. The short answer is no. They both testified about their years on the police force. I believe one had 12 with the Brockton Police. The other had 7. One said he had made numerous drug arrests at this location. Didn't say for what kind, but none of them testified that they had, I believe what is necessary, specific training or experience in drug identification.
Hypothetical. If they had testified, I've been an undercover officer for 10 years and I've made, 1,000 buys of cocaine and I've had it in my hand, I've seen it, blah, 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 then would you consider that the Commonwealth would have met its burden of proof on the element of cocaine?
I would say no to that, and I would reference the decision in Commonwealth versus Dawson, basically saying that it would be an unusual instance where a visual identification of the substance would be sufficient.
What if the officer said, I smelled it, and I know the smell of marijuana?
I think you could argue that that's sort of a marijuana field test at that point.
What was the marijuana testimony in this case?
There was no testimony about the smell or anything. It just green leafy substance. There was no testimony about, obviously the jurors and the judge could see the evidence, but there was no testimony. Was it a whole leaf that you could say the leaf looked like what I know
I
to
take
be?
it, Ms. Cox, that if we are under harmless beyond a reasonable doubt, the issue is not sufficiency of the evidence.
Correct.
The
Yes,
issue
it's a
is
different analysis.
you have to you don't take out the drug certificate. You
Right,
leave
that would
it
be
in. You
substantial
leave
risk.
it in, and you look at all the evidence. And the question is, did this certificate, can you say, influence the jury?
Right.
Not what else was there. You don't take it out.
Yes. Our
Right.
position would be that there.
What was the
error
jury?
not
What was
harmless.
this? Is the jury trial?
This was a jury
What was the
trial.
jury instruction?
They were not given the special instruction that is given in some cases about the prima facie value of the certificates, but I would note that the three certificates
What did the
themselves-
judge tell the jury they had to find? Did the jury have to find that this was an
Yes.
illegal substance?
Right, but he didn't go the one
No,
step
I understand
further
that. So
and
what did he
but
say? You must find what?
That
What-
this one is cocaine and that this one is
Okay, so
marijuana.
you're sitting around the table, right, in the jury room,
The jurors do have the three certificates, which
Right.
each have the
and the first question the jury foreman says is, does everybody agree that this was cocaine? Yep. Why?
because of their certificates. I mean,
Well,
that's
they have the exhibits too, don't
right.
they?
Yes,
So they've got that in the jury room as well.
but I would argue that we don't know that the jurors have any specialized knowledge either to be able to visually identify. Yep, that's crack cocaine, and yep, that's
And that it's
marijuana.
not baby powder or sugar
Exactly.
or
The
whatever.
most problematic, obviously, is the white powder that really could
If
be
you
anything.
think you could take judicial notice of what marijuana looks like?
I
we could
would
take
leave that to
judicial
the
notice of
personal
what it
judge,
smells
I
like.
think.
So.
I don't want to cast that aspersion on anyone, but
In fact,
maybe
I can
not.
tell
I
you
mean,
about an
especially
experiment on
where,
that.
where
Oregano.
marijuana is commonly packaged, sort of crunched up. I'm not sure that you could take judicial notice of that. Leaves, perhaps, we've all seen it on sweatshirts or in whatever context, but where we
I'm
don't
not
know
asking you to
here-
reveal
yeah,
anything.
right. Right. I plead the fifth, but so here, obviously, the certificates were the most compelling and conclusory statements on this, saying it is marijuana, it is cocaine, and where the other testimony beyond that is merely the conclusory statements. Yep, it looked like that. I think this doesn't pass the harmless error test.
Well, I take it when we look at harmless error, not only do we look at all of the evidence as it was admitted, but we also look at it in the context of the trial that was actually tried.
Right.
Not the trial you would have tried if, in fact, you could have kept the certificates out.
Right. And my point to that would be that again, acknowledging that in his closing, defense counsel did say, I ask you to find him guilty of the lesser included offense. That can be objectively seen as a response to the evidence after it came in. Defense counsel and Commonwealth counsel are in a position that after the evidence comes in, you have to address it. So that would be my response to that. So,
But of course, if in fact you were contesting, leaving aside the Commonwealth has the burden to prove, but they don't have to admit certificates to prove the substances were the substances. But if you in fact were contesting that, presumably you would have asked some questions about it.
agreed. I mean, certainly where there's field testing, you can ask the officers questions about that that would resolve the certificate problem. But here, they could have asked the officer, well, how much marijuana have you seen? Have you ever reviewed any that came back the tests were negative?
And the problem in this case was not the certificates. The problem was the fact that the testing showed that the substances were marijuana and cocaine.
Well, it certainly doesn't help. But there's the amicus briefs have included the NAS report from the summer and some other law review articles demonstrating that, and the Melendez-Diaz opinion itself, Justice Scalia recognizes the analysts are not infallible. I mean, they have different levels of training.
No,
they
I
have
understand, but
different levels of equipment.
if you're making a strategic decision, right, and you've
Yes.
got no reason. I mean, previously, if you had some reason to believe, and we've had a couple of cases where somebody challenged the certificate and
Right, with their
whatever
own
it was,
expert or
for whatever reason, that's fine. But if you don't have a reason to believe it, I think it's a little hard to fault trial counsel when they may be trying to persuade the jury on some other basis. So it is this case, but it's this case with the drug certificates in front of you.
And I would just stress again that counsel didn't engage in any behavior that I would view as a concession until his closing argument after the evidence came in. So thank you for your time.
Thank you, Ms. Cox. Ms. Lee, good morning.
Good morning. Mary Lee for the Commonwealth for the Plymouth District. The first question that everyone is asking is what's the appropriate standard of review when a person doesn't object at their criminal trial between the issuance of Verde and the granting of cert in Melendez-Diaz.
Ms. Lee, are you suggesting that we should tell our attorneys that they should disregard a decision of the highest court of the state and tell them that despite the words of the highest court of the state, they should be lodging an objection before the trial judges?
If they want to preserve a federal constitutional issue, then they have to object. And that's not ignoring the decision of this court. It's acknowledging what this court has itself said, that it is not the final arbiter.
No, we don't have
of
to
the
say
federal
it. We're not,
constitution.
right? We don't have to say
You
it.
don't have to say
We're
it,
not.
but you have
On
said
federal
it.
law, there is a court that is the final court.
Absolutely, and everyone knows who it is.
Yeah.
And if it wasn't the United States Supreme Court, Crawford wouldn't have created such a tidal wave of change in our courts.
Well, maybe some of us should have been paying a little more attention to the confrontation clause.
Well, they changed the confrontation clause, and they...
Well, I don't think so. And I think what they did was give meaning to the confrontation clause.
And that's what Justice Scalia was writing in Crawford. But in doing so, they undid 20 years of jurisprudence.
So then
by
in every
overruling
trial where
Ohio.
there's a federal constitutional issue, you're saying that the defense attorney should object despite the fact that our court has spoken, and trials should take even longer because there'll be all these objections, and some judges may not understand, and they'll have to call counsel up to the bench and say, why are you objecting? And counsel will have to say, because it's a federal constitutional issue, and even though there's XYZ case, I'm preserving that issue. So, I mean,
Yes, because they have to. That's what the law requires. An objection does not just serve the purpose of getting the trial judge to do what you want at trial. An objection serves the purpose of preserving the issue for appeal, and all
Why
lawyers know
can't
that.
you rely on the SJC knowing what it's doing?
You
Because
need not
you-
answer that question.
You know what you're doing, but you're not the final door down the hallway. And so we can rely on you, and we do rely on you, and we know that this isn't the last stop at the train station.
And going back to the reason why we require objections, you said one reason, of course, is to see if the judge can repair the error. But of course,
Or prevent the error from occurring.
right, but of course that wasn't really available here because the judge would say, I'm just a
Fair day.
lonely Superior Court judge and I've got the SJC and they've said it, so I'm bound.
Exactly.
So what is the other reason why we should say that a defendant who had a lawyer wise enough to object is in a better position than a defendant who didn't have so wise an attorney?
Because there's, as I said, there's two purposes for an objection, and that is, the second purpose is to preserve the issue for appeal. If you want to
But
preserve
what
it-
does that mean? I mean, it's still preserved, just a different standard of review.
Right, and that goes through the history of waiver, and I'm fully aware of this court's decisions in Randolph and Bly, where you said waiver doesn't mean that we don't consider the issue anymore.
Well, those are murder one cases. It's a little different.
Right, but
It really is different because
well,
murder
and-
one we have the overlay of 33.
right, and the way the waiver, that decision and the waiver rules have
Yeah.
been treated is that every issue, preserved or not, is going to be reviewed
Substantial risk.
for substantial risk. And
Right.
I believe I read that in one of your decisions, Justice Cordy.
Although certainly in the United States Supreme Court, that's not the case.
That is not the case. Exactly. You're way ahead of me.
We always
If you
are.
want to preserve your, yes, I'm glad somebody is. If you want to preserve that federal constitutional issue, you can't rely on this court's decisions in Randolph and Bly. You have to say, I object.
And even if
I
the
ob-
Supreme Court has said otherwise in other cases, if you want to preserve the issue saying, Supreme Court, you were wrong, you've
If
got
you
to
want to
object.
say that Verde is not correct, and we think the United States Supreme Court's cases are going to go the other way, you have to say, I object. And most respectfully, I don't think that takes that long at trial. You know, okay, maybe you have to explain the rule to the judge one day, but you're not going to have to explain it to them in the next case, people are going to say Crawford, Verde, end of
So, Ms.
story.
Lee, you have just persuaded me that looking at it as a waste of time is not the only way to look at it. So look at it through clairvoyance, right?
Okay.
So now we have we before the petition for cert has been granted.
Yes.
Before the petition for cert has been granted, and of
After
course
Verde.
we know from the appeals court decision on Vasquez that at least in their informal search of their own cases pending,
Sure.
that there were defense attorneys who objected.
And I've tried to be helpful to the court in pointing out some of the cases that I could find as well. There were attorneys who did object during trial
Right.
in that period, and I've listed them on page 20, both published and unpublished. Some of them are gun cases, some of them are drug cases. Those attorneys weren't clairvoyant, and here's why you don't have to be clairvoyant to know this issue. One, you have Crawford saying, testimonial, okay, all of America, we are changing the rules, but we're not going to define exactly what we mean by testimonial. So you guys are going to have to figure it out yourselves, but here are some guidelines. Okay, then we all run with it, and this court says Verde, because of the public records exception. After long-established law in Slavsky, which dates back, Slavsky relied on authorities that date back hundreds of years, which is what the dissent took up in Melendez-Diaz. And so this court's decision wasn't badly reasoned. This was a very well-reasoned case, so I could see why people would want to rely on it. But you were not the only court that was deciding the issue. And I've listed the cases on page 18 of my brief, showing the split in the states. So any attorney paying attention to this issue knows this isn't the end of the day, because there's no full agreement on it, and we certainly haven't heard from the last door in the hallway, which is the United States Supreme Court. But then something big happened. What big thing happened? And it's Gonzalez and Davis. This court on August 29th, 2005, decides the 911 spontaneous utterance issue. And then in Davis, June 16th, 2006, the United States Supreme Court came up with a very similar analysis, and they are perfectly parallel, and both are currently used as good law. Now, that would tip off everyone in Massachusetts. Well, the SJC made their decision in Gonzalez, and now it's been pretty much affirmed, not using all the same words, but pretty much affirmed by the United States Supreme Court, giving all the lawyers who are watching this issue the tip-off on June 16, 2006, that you're not the last stop on the train. But what else did Davis do? The Davis case had a companion case, the Hammond case. And in the Hammond case, the United States Supreme Court overruled the Indiana State Supreme Court on the issue of Crawford's interpretation of testimonial on the issue of 911 and spontaneous utterances. Anyone trying these cases, dealing with any type of hearsay going in at a trial level, is now on notice that every state Supreme Court decision is subject to review and reversal by the United States Supreme Court. That happened on June 16th, 2006. The defendant in this case was tried more than a year later on September 17th, 2007. And that's why I'm saying you don't have any basis for saying he was not clairvoyant or didn't know about this issue. There's been no ineffective assistance of counsel claim in a motion for new trial where he stood up and said, I didn't know what I was doing. I was relying on Verde and thought that nothing could change Verde. Why would we assume that all these attorneys who didn't object on an issue that they weren't pursuing at trial, in a case where everyone knows this is drugs, why would he object to it and risk the chance that the Commonwealth would say, oh yeah, we'll call in the chemist, and then the jury can hear exactly what the purity was and how good the testing was. And Commonwealth versus Jordan is a very good case that shows that just because a defense attorney can challenge hearsay doesn't mean he should challenge hearsay, because it can improve the case against him. He didn't want to show how good the cocaine was in this case. So that's why I would suggest that the defendant's brief is incorrect, that we should be saying harmless error after cert was before cert was granted. I think if you're looking for a controlling date, it should be Crawford, as the Vasquez decision on the appeals court says. If you're not satisfied with that because of Verde, you're afraid that people were misled, they could not have been misled after Davis.
Why?
because in the Davis and Hammond cases, a state Supreme Court was overruled on the
Of
Crawford
course.
interpretation.
Of course, that's theoretically possible. That doesn't tell you that Verdi's going that based on what was said in Crawford, that Verdi is going to be overruled.
No, but it's saying that Verdi could be overruled.
No, but
But
we
of
know
course we
that.
know that.
We know that.
Exactly. So if you want to preserve the federal constitutional issue, all you have to say is I object, because everyone knows that everyone knew that Verdi could be overruled. Now,
When you
many
say
of us thought
everyone,
Verdi
you-
was well decided and wouldn't be overruled. We were wrong.
So is it your view then that we should not even evaluate for substantial risk?
Under the Freeman standard, prior to Randolph and Bly, the decision was left to the discretion of the appellate court whether to review for substantial risk or not. There are 5 standards. One of them is clairvoyance, one of them is substantial risk, and then there's other things. And after Randolph and Bly, the way I have read Randolph and Bly is that every unpreserved issue should be reviewed for substantial risk. As the Commonwealth and, as an attorney to this court, I suggest that that's not a good standard for waiver. I think waiver needs to be there, because when someone doesn't object to something, then the Commonwealth doesn't put in all the reasons why you're offering this evidence or why it's relevant. We might not, like, for example, with the experts in this case, you want to know, don't you, what kind of expertise these police have before they say that's marijuana and cocaine. And we have very limited information about it, because when they said that's marijuana and cocaine, or I suspected that was marijuana and cocaine, nobody objected. So nobody put in all
But
their
I think even before
expertise.
that, if nobody objects to the certificates, I don't think it's too far a leap to say it's the most powerful evidence, because
Sure. Yeah, it's the
right,
most
because a
powerful
police officer, you look at the white powder. I mean, I don't know about it. Just take white powder. Forget about marijuana. Just take marijuana versus oregano.
Sure.
White powder. Cocaine versus talcum powder. But if you have the certificates, and if that's that's why the defendant is not objecting.
I agree. It's powerful evidence. It's prima facie evidence. And then then you get to the question in this particular case, and this is a tough case, and of course, when this case was chosen, I was like, they didn't choose the one with the admission, or they didn't choose. I was looking at all the other cases that I had where I had better arguments. But it was pointed out to me that, well, this is a case where it might make the difference. The standard of review might make the difference. So I guess very good choice, maybe for you, but harder for me. So I'll go into the facts about harmless error and substantial risk. I think the standard of review should be substantial risk. You don't just have the 2 police officers who have 7 and 12 years experience, respectively, one of whom is a sergeant who oversees the younger police officers. But also, I believe one of them had had some experience in that particular area regarding drug cases. But certainly there was evidence that this was an area known for drugs. But you have the defendant acting like this stuff is cocaine and marijuana. He's having an argument. Well, he's shirtless at 2:20 a.m. at a gas station, having an argument with someone. He's beating his chest and yelling and making a scene, which is what called the attention of the police over there. And then when the police are trying to talk to him, he throws the stuff from his waistband in the back seat, and they get them. And then there's stamped baggies in the car, and there's evidence that you use the stamped baggies to package illegal drugs. That's how they're packaged on the street. Some of them have stamps on them, an Apple stamp. So the jury has the substances, and they have the baggies. They have the opinion of the expertise. But then, as he's being arrested, they have him in the back seat of the cruiser, going to the police station, which is not very far away. He jumps out of the moving vehicle. He gets the handcuffs in front of him, and he's rolling down the window. He jumps out of a moving vehicle. Is this a person who's carrying a beat bag? Who knows he's going to get away with
He's
it?
acting bizarrely to begin with. I mean, that could be seen as just...
So, Ms. Lee, here's my question. I get the substantial risk. Tell me why this isn't harmless beyond a reasonable doubt, assuming we don't agree with you on that standard.
I think this is a really close case when it comes to harmless beyond a reasonable doubt. My sister's pointed out all the things we don't have. We don't have an admission from the defendant. We have this implicit knowledge that, he's not acting this way with a beat bag or with sugar. You have, and there's a case, I'm sorry, I think it's Marvin or Martin in my brief. I cited in my brief, it says you can draw that inference. And then you have the not live issue part. And I think that's really important here, because this is a case where they're saying, you know, he's using the terms cocaine and marijuana. He's presuming they are drugs. He's
But
not
isn't it not a
objecting.
live issue because the defendant knows you've got the certificate? And how can it be a live issue when you have the certificate?
Or is it not a live issue because the defendant knows it's cocaine?
I don't know. I don't know. It's
Or it
possible.
failed the test. I mean, the certificate is just one way of getting it into evidence. You could have called
I could have
the
called
technician.
the
I mean,
chemist, sure.
and if push comes to shove, you might have
We
called
could
the
have done a
technician.
field test.
No, there's always the
So-
other case. Anyway,
So, at any rate, I would ask you to consider my brief, and I appreciate the opportunity to speak to you today.
Thank you.
you.